We filed in federal court in Texas against the rulemaking, basically on 5 issues. The reason there were 5, because those are the 5 we thought was the overreach of the USDA APHIS did not have the authority, and you hear a lot of this today when Trump's in the office, did not have the authority as an agency to do something that was not in the Horse Protection Act, which is a congressional bill. So we filed. The last paperwork date on that was December the 20th. December the 20th, December the 9th, and November dates, those were agreed on dates going into this lawsuit from both parties. In other words, the Department of Justice representing the USDA and our attorneys representing the industry and the 2 plaintiffs that we had out there. These hearings aren't in-person hearings. These are hearings and legal questions that are based on law. So we don't go in and we don't testify. We don't call people to the stand. We submit our briefs and our paperwork, and they submit their briefs and their paperwork of why we think they're wrong and why they think they're right. So the deadlines were done. If you remember, the implementation date of the enforcement of this rulemaking was stayed off to February the 1st by the department with an agreement from a federal senator in Tennessee. The only thing that took place in the summer was the HPI. They could hire HPIs and train them. Everything else was held off to February. So going into this, the February date was looming. So going into this, the agreement was with the parties, these are the dates that we're going to hit to file our briefs and our motions, and there'll be no motion for an injunction filed if everybody meets these dates, and then they ask the judge to rule on it by the end of January because of the February start date. All right, so go forward. Trump comes into office. He puts a thing out called a 60-day extension. He said to the agencies, if you've got rulemaking, even though it's final, which ours is, but you want to reconsider this, you got 60 days to open it back up for comments, anything like that. So it got it delayed to April the 2nd. That concerned us, the industry leaders, that it was going to cause the judge not to rule. In other words, he didn't feel the pressure to have to rule because of February.